Welcome back. This is episode 4 of What's on Tap. Guys, we're getting some great reaction. I mean, I don't know about you folks, but we're getting a lot of people. We're getting people asking some good questions, and they're kind of excited about what we're doing here. You've been seeing the same thing?
Same thing. People have been reaching out with, kind of nuanced questions, which is always good to be able to help them with those.
Absolutely. And I'll tell you a quick story. So I was at a conference a couple weeks ago, and someone walked up to me and said, "Hey, aren't you the What's on Tap guy?" I said, "Yes, I am." So we're becoming kind of mini stars. What can we say? We're the What's on Tap stars. Got that going for us.
And all the swag we're giving out to everyone.
I think it's all about the free swag, to be perfectly honest with you.
That's what gets the people coming back.
Absolutely. So what do we got today? So what we got today is legal collection strategies, maximizing your bottom line. So folks, the same as before, keep the questions coming in. We love to answer them. Please keep them coming in. Continue with those surveys. Those surveys provide great info for us. The PowerPoint is available at the end. The recording will also be available to you. So please keep them coming. We're enjoying it. We're having fun with it. And it's becoming a better time each time we do it. And with that, Scott, take us on. Let's see, what do we have here today? Let me pass it over to you.
So this is Neshaminy Creek, the Shape of Hops to Come. It's a fantastic beer. I had one the other day. I've had several of the beers made by Neshaminy. They haven't disappointed with any of them. They have several tap rooms that you can go visit. I believe at the moment 3. And I have not yet visited one because none is local to where I live, but I've heard nothing but good things about them. So I highly recommend this particular beer.
Great. We'll put that right up there for our team. So what do we got? Let's talk about the legal collection strategies. Scott, why don't you kick us off?
So legal collections has grown, I would say, over the last number of years because largely when a loan goes into default, you have 3 options effectively on how to deal with the loan. One is to keep it in-house and try to collect it yourselves. A lot of smaller places aren't necessarily equipped for that. You can send it out to an outside collection agency to try to collect. But from my perspective, the day of dialing for dollars, as we used to call it, isn't necessarily a productive avenue to go down anymore.
Now, why is that? Why do you think that is?
People just don't respond the way they used to. As if you're like me, you get dozens of robocalls from who knows where all the time. You're calling people on their cell phones. They're not responding to you. There's the added question of whether or not you're even allowed to call their cell phones under certain federal laws. So from my perspective, the easiest thing to do, or the best way to get a response, is to send it to our office or to file suit, because you get a letter from us, people respond to that letter. But more importantly, when you make a decision to file a lawsuit, the sheriff, a constable, a notice from the court in New Jersey, which would be mailed, something along those lines makes you pick up the phone and reach out and say, okay, I see you're now serious about wanting to be repaid on this.
Well, let's take you a step back. So before we even get into the suit process, which are the folks out there, they've made the decision, they said to themselves, you know what, we've got these defaulted obligations, these defaulted loans. We're looking to send them to a collection law firm like Weltman. So what documents do they need? What are you telling them they should bring to you so we can get things started for them?
We always say the more documents you can get us up front, the better. We would ask for the loan agreement or a copy of the applicable credit card contract, account statements, as many as you can give us, or a payment history, a balance history showing this is where our amount we're seeking comes from. Always having the application is especially on a credit card, but any loan application is great because it has the additional information sought by, usually the court is the one who says, do you have the application? Even though you might have years of statements showing use, courts are in some ways hung up on the old ways of business and they want an actual application. And then anything else that you might think would be relevant to the account. Again, not all of this is necessarily on initial filing of suit. But the more you can get us up front, the better we'll be able to handle the account going forward.
Well, you talked about account statements. So how does all this play out with, probably it's been a couple of years now, or at least a year with Reg F. So there's different requirements on our clients now to make sure, and us, to make sure the information is correct, that the balances are there. So what are we looking for those balances?
So we're just looking for a document that if you're saying $4,223 is due, where does that balance come from? What are your interest rates? What's the principal amount due? What's your running interest? All of those numbers need to be provided and have a basis to comply with Reg F. You just can't send us a document or a number anymore saying we show that there's $4,223 is due on the account. We need, and you need to protect yourselves, something that shows this is where our dollar amount is coming from.
And then isn't it true also with Reg F, you got to let us know, you got to pick one of those significant event categories, right? Whether it be the transaction date, the last payment date, correct?
Last payment date, the closing date, or the charge-off date. There just has to be, there's a certain number of factors you can look at. You pick one of those days, and that's the date as far as calculating the balance due. So the more certainty, some dates provide more certainty than others as far as where your balance due comes from. A charge-off date, always, you're going to have a certain number due on your charge-off date. Or your last payment date, you're able to, as of that date, this was the amount due. If you pick some other days, it's a little bit more fuzzy where how those balances might come about, but on certain days you can 100% certainty say this is where our balance due comes from.
And that's a new requirement from Reg F, right? Providing that information.
As that regulation has gone into effect, that has bolstered the need for these additional documents.
Now, so once these documents are produced, when a person comes to you and says, yeah, I want to get these suits filed, I want to move forward, what do you describe to them as the benefits of filing a suit versus you talked a little bit about the robocalling, the dialing for dollars type situation, maybe not being as effective in the past. What do you see as the benefits to a person or a client, an institution, for filing suit, actually filing it?
Well, the number one benefit beyond getting their attention, that's probably the number one benefit, where they were ignoring you before, suddenly they're willing to call and deal with this. The number one benefit is the ability to obtain a judgment, which in New Jersey and Pennsylvania are both good for 20 years. So it lengthens the length of time you can really go after, seek collection on a loan. And if they own property, it gives you the benefit of, if you have an unsecured loan for the $4,000, if they sell the property, they don't have to pay you. As where you get a judgment, it's a lien against that property. They have to pay you. I can think of any number of situations where we have judgments that are 10, 12 years old. You just kind of have them sitting off to the side. You're making collection efforts, but it hasn't paid in 10 years. And then out of the blue, you get a letter from someone, a title agency, saying, provide us your payoff, this house is being sold. I had one where it was a rather substantial judgment of more than $200,000, and the executor, the person died, the executor of the state reached out and said, we're selling the house.
Great phone calls to get, right?
Yeah, they're great. It's found money to some extent, and in order to close on to deal with the property, they have to pay your judgment. And so it provides you more of a long-term solution than hoping that you're going to get paid, and then after a couple of years realizing they haven't responded. We're now beyond the statute of limitations. We can't file suit. At that point, it's a loss. It's almost impossible to get payment on that at that point.
Okay, so Scott has taken us through the process of, hey, here's what you need. Here's the decision you make to file the suit. Here's the documents you need to get that suit going. Andy, so talk us now through what is the suit process like? What does that look like for our clients?
So first we do is prepare a complaint, have the client review it, and once the client gives the okay.
What's complaint?
So what the complaint does, the complaint sets out basically what we're alleging. In a collections matter, it is, we lent the defendant money, they haven't repaid, they owe us X number of dollars, then we provide some supporting documentation like Scott referenced, application, statements, account history to substantiate our claim. And then we go ahead, have it filed, and then have it served. And once it's served, there's really three potential outcomes. One of which Scott mentioned, the defendant does nothing, we get a default judgment. Another possibility is the defendant might, usually through a lawyer, file some sort of motion to have the matter dismissed prior to trial or arbitration. In that case, again, as Scott mentioned before, with a reasonably well-documented loan, any effort to have the matter dismissed prior to arbitration or trial is typically unsuccessful. The third possibility is the defendant files an answer. An answer is a response to what we alleged in the complaint. And once an answer is filed, there's typically an exchange of documents if the defendant requests it. And the exchange of documents is us providing all the documents the client has given us, loan documents, statements, account history. And after that, very often settlement discussions. And there's two types of...
Well, let me cut you off there a little bit. So you described a few different ways a suit goes through the process there. I'm just curious as to the timeline. Let's say that typical one where you get that complaint file you talked about, and then you get your judgment, no answer being filed. What are our clients looking at as far as how long does it take to get that judgment, typically?
So typically, typically the defendant, if they don't file an answer or respond with a preliminary objection or some sort of dispositive motion, we send them a 10-day notice, and at that point they're looking at maybe 60 days in terms of processing to have the matter to actually obtain a judgment. It does depend on the county and how quickly they process things.
Would it be fair to say, whether PA or Jersey, you guys have the experience there, 3 to 5 months in a typical case where there's no answer to get that judgment?
From the time the complaint is filed?
Yeah.
Yeah, I'd say.
Yeah, that's a rough estimate. Providing there's no issues with service, yeah, you should have a judgment certainly within 3 to 6 months.
Okay, well, let's talk a little bit about the service there. So, Andy, in Pennsylvania, my understanding of service is, whether it's what's called district court or common pleas, the effect of that is the sheriff coming to that person's home. Is that fair to say?
Yes, well, coming to their home and coming to their home with the document that we're intending to file.
It's pretty effective, wouldn't you say, as far as getting someone's attention?
Well, absolutely. The sheriff comes knocking on your door, you're going to pay attention, and in most cases, cause you to sit up and take notice. Although, again, in some cases, people don't respond, and that's why we have the default process. Because, again, once we have default judgment, we can go ahead and proceed with collecting on that judgment. And
that's one of the benefits, you would say, of filing that suit, of having the ability to that sheriff to just show up and say, here's the paperwork. And you mentioned it. That's effective, right?
You can't ignore a sheriff knocking at your door. I mean, you can, but
it's not the best idea.
Not typically recommended. So, yeah, absolutely. That's definitely one of the ways to effectuate some activity in the process. Absolutely.
Okay, now you also talked about those situations where what's called an answer is filed. So an answer is basically a response to a complaint, right?
Right. An answer is a response to a claim. Sometimes they'll raise some additional assertions that we have to investigate. But it's a response to the complaint where they typically deny owing the money.
Now, is it fair to say you like an answer too? Because when an answer is filed, doesn't that give you kind of a doorway or a communication method to talk to someone about resolving things, right?
Absolutely. So sometimes the answer is filed by the defendant. They personally fill it out. But oftentimes they'll get an attorney. And once we have an attorney with pre-relationships with most debtors' attorneys, we can go ahead and reach out and say, hey, attorney so-and-so, looks like you filed an answer. Do you want to settle? And oftentimes those conversations are fruitful because attorneys typically want to settle rather than going forward with the expensive and lengthy process that is litigation.
And also the flip side to the customer, consumer who you filed that suit against, he's got to pay that attorney, right?
He does have to pay that attorney, which does definitely put a little pressure on them to settle the matter. Because, and you pay for your point, you pay the attorney win or lose. So even if we go to trial and win, they now owe us the full amount and the attorney.
And you're going to put some pressure on that litigant during the course of the lawsuit, which is going to incur some more cost for that person. So there's a benefit, right?
There's absolutely benefit, an incentive on their side to go ahead and settle. And also a benefit on our side because we get some certainty in terms of that we're going to collect, or at least promise to get paid, and the client has some certainty in that regard.
Okay. Now, throughout the suit process, is it fair the client's role is not overly too great in the initial part, right?
Absolutely. Client's role is to basically provide us the documents and then maybe review the complaint, but that's about it.
Now, if you get one of those answer files you're talking about, will there come a time when we might have to ask the client to appear at an arbitration, a hearing, a trial of some sort?
Absolutely. That's obviously if we cannot get the case settled, yeah, it's possible that we will ask the client to attend trial or arbitration. However, in Pennsylvania, if a client cannot attend an arbitration or a trial, we can still proceed with the litigation. So it's helpful if the client appears, but if they cannot send a witness, if the claim is under $50,000, we can go ahead with trial.
And your ultimate goal when you file this lawsuit is to settle the case, right? To resolve it, get the client paid?
That is the goal.
And then the secondary goal would be what? Getting the judgment?
Getting a judgment and then working on the post-judgment remedies to get paid.
Okay, I guess that'll flip it over to me on those post-judgment remedies, right? So, I mean, realistically, there's probably three, well, there's many post-judgment remedies, but there's three that make the most sense from our perspective. So you guys, Jersey, Andy, you work Jersey as well, so a lot of this stuff is similar, and I'll let you guys jump in there if you see some differences. But once you get the judgment, what I always tell folks is, getting the judgment is the relatively easy part. What separates attorneys from the good ones to actually the ones who know what they're doing is once you have the judgment, how do you collect upon that judgment? That's the key, because I can tell you, none of our clients just want a paper judgment and us walking around saying, hey guys, we got you this beautiful paper judgment with absolutely no money. Wow, pat on the back there, right guys? Did a great job for us.
Yeah, that doesn't really get them what they're looking for,
at
least initially.
Yep. So that's why it's all about post-judgment, right? So let's talk about that. So post-judgment is basically you can do a deposition, interrogatories, and aid of execution. So what that first step is, it's very little cost to you guys, meaning the clients. We're going to send some questions out, and we're going to ask the defendant to answer those questions to say, tell us about your finances, tell us about your stuff, tell us about, do you own a car, do you own some property? So the purpose of that is to get their attention. And Scott, correct me if I'm wrong, in New Jersey, every time I see this, it just boggles my mind. In New Jersey, you're in interrogatories. There's a court notice on there, right? To say if you don't respond, what happens?
We can get a warrant for your arrest. It's right on the top of the paperwork, which some people have, clients are like, we don't really like that language, and I say, it's a court form. We don't have a choice in that response to say, if you don't respond to this series of questions, you could be arrested. Which usually gets people to call you back because they get that and they start to freak out a little bit of, I don't want to be arrested, which would require us to take the next step to move that forward. But there is a notice on there that says if you fail to respond, it could result in arrest. And
it amazes me as you said it, that's the court's language.
Yeah,
that's not ours.
We wouldn't put it on there if we didn't have to, but it's the court form, and we have to use that form.
To get back to what Scott said before, once you involve law enforcement, people are much more likely to respond.
Yeah, so I mean that's the thing in the suit process, right? So those depositions, those interrogatories, that is a means to gather information. And if they don't respond, well, yes, some other remedies involved there. You can file some motions to enforce it, things along those lines. But then that takes us to the next remedy, bank attachment or wage garnishment. And Scott, I'm going to have you talk about wage garnishment in a little bit, but for a bank attachment, we kind of talked about that in our prior episode as to what you as the institution need to do when you get that attachment. Now we're going to flip it around. We're filing that attachment. So what we're doing, we're going to that bank, right? And we're saying, hey guys, we want the money from this judgment. That's an effective remedy, isn't it? I mean, that really, you're sitting there, your life is going on as normal, right? Life is good, going to my job, everything's fine. All of a sudden, you put your ATM card in, you try and tap to buy something, and you get a notice saying your account is frozen. Pretty effective, right, guys?
Yeah, that always results in people calling in, usually yelling, but people calling in about how do I resolve this? I can't have my account frozen. I need the funds that are in there to do A, B, or C. And we do our best to advise them on where the situation stands. sometimes we are able to work with them, and then sometimes, depending on what they're looking for or what they want and the status of the case, we're not able to really help them very much, help them to the best way we can. We can't really do much for them.
And New Jersey, you guys got an interesting additional twist. So Pennsylvania and New Jersey both can do these bank attachments. You guys in Jersey, not only are you going to put on your forms that we're going to arrest you, you guys are now also going to say we're going to take your wages. So tell us a bit about that.
Yes, so Pennsylvania, you're not allowed to do wage garnishments, directly at least. In New Jersey, you can do similar process to a bank garnishment. There's a little bit more notice. You have to send them a notice saying, we have a judgment. Our intention is to garnish your wages. There's state statutory amounts that you have to make above, bi-weekly you have to make above. I don't know the numbers off the direct top of my head, but there's an amount that says anything above this amount is garnishable. A lot of times people then call in when they get that initial notice of our intention to file a wage garn. Sometimes they can file an objection saying they can't afford a wage garnishment. That then goes before the court to determine if they don't respond or if the court denies their objection to the wage garnishment. At that point, we get an order similar, just like a bank. We get a bank garnishment. We get an order saying the employer has to pay us a percentage. There's a formula calculation, and a percentage, however that calculation works out, we're entitled to X percent of their wages. And then we'll start to get a check either from the court officer or the sheriff, or it's at that point is when the person calls and their employer gets served, and at that point, that's when they realize how real this situation is and that they need to deal with it.
It's another great tool, isn't it?
Yeah, and at that point, a lot of times they just want to work out a payment plan, and sometimes it's also on the client. It's in some way the institution to realize where we are in the case and whether or not to accept that payment plan versus who knows where the wage garnishment might turn out. The other issue to point out with regard to wage garnishments is there can only be one wage garnishment at a time. So if someone already has one going, we regularly see situations where we're the third garnishment in line. So given the amounts that are taken out, you might be waiting for a garnishment a couple years before you even start to receive funds. You're sitting there waiting, but
it's absolutely it's a phenomenal tool for Jersey, right?
Yeah.
Absolutely phenomenal. That kind of leads us to the last element, which is a personal property levy. Andy, you kind of described the situation previously. When that complaint is served, the sheriff is actually knocking on your door. This is where it goes to the next level. So now you've got your judgment. Not only is that sheriff knocking on your door, but he's walking in your house with his clipboard and walking around your house. Oh, bed, TV, walking all these things. Can you imagine? That's an impact, right? When the sheriff is actually walking your house, basically taking what's called an inventory, right?
Absolutely, because you realize if things go forward, the sheriff can seize those things and sell them. So if you don't want to lose your bed, you're going to go ahead and try to make some sort of arrangement with us.
Right, you're going to reach out, you're going to contact us, and we're going to work with you, right? We're going to find a solution that makes some sense, right?
Absolutely, because we want to get paid, and the sheriff walking through your house is simply a tool to encourage you to go down that road and work with us.
And all these things we talk about, guys, it's all about, obviously we're representing our client. We want to make sure that things go well for them, but our clients also want to make sure we find something that makes some sense for everybody, right? We're trying to find a means to get our client paid and also come to a conclusion that works for everybody. Is that fair to say?
Yeah, because you want to come to a resolution, especially if it's a monthly payment situation, where ideally you get it paid, the client would like it paid in X number of months, whatever the amount is. But you also want to make sure that it's an amount that the consumer can maintain that payment arrangement, or else you're going to just end up back in the same spot.
You don't want them to default again, right?
Yeah, they're working a minimum wage job somewhere. You can't be asking them to make $600 a month payments because it gets it paid off, because they're just going to end right back up. You're going to end up in the same spot. So that is a factor that we always take into consideration when trying to resolve
Absolutely.
cases.
So I think it's a good break to move on. I think we got some questions again, so let's see what we got here. I think the first one here looks like it'd be a good one for Andy. Let's see. What can be done by the institution to improve its chances of prevailing at trial? So what can they do to put them in the best position to succeed? That's a very good question.
Yeah, so to me, it really starts with documentation and providing the documentation to us. The more documentation we have, the fewer avenues that a defendant or their attorney can try to go down and argue that that isn't owed or we're not owed what we're asking for. The other thing is, if possible, sending a witness. A witness is, it's one thing for me to go to court and say a bunch of stuff. I find much more effective if a witness comes and can walk through each document, because they can do it a lot more authoritatively than an attorney can. Because, again, they're employed in the institution, knows the institution, quite frankly, better than we do.
And it's a partnership, right, between us as the attorney, you folks as the client. It's a partnership. We want to work together to get the best result for you, right?
Absolutely. And sending a witness, having a well-documented loan are two things to do that.
Okay. Now, we got more questions here, but I'm also seeing we got a lot more questions coming. But I think this might be a good time to kind of wrap it up. And we've said it before. We'll say it to you again, you guys. We will answer each and every one of these questions. We're going to get you your responses within 24 hours because we know it's important to you. So same thing I would say. Oh, I do want to mention one more thing. If you've liked what we've done here, please, please, please go to Coffee with Casey. Go to our Ask a Pro series. You can also go to weltman.com/events, and you get to see all these webinars. And we've got a lot of people putting some great information out there. So please make use of it. They're there online. They're free for you guys to grab onto. As it relates to this, with your registration, you are in the mix for some of this great swag. People are loving the What's on Tap swag, and we're getting more and more each time. Our marketing guy, Chris Kimes, he's complaining all the time about all the swag he's got to order. So let's make sure Chris complains a whole lot more about all the stuff he's got to order. So with that, again, recordings at the end, PowerPoint's there for you. A final reminder, our next episode will be Collection of Deceased Accounts, the Forgotten Strategy to Enhance Your Recoveries. We got that scheduled for August the 22nd, so please join us for that episode as well. Feel free to reach out to Andy, Scott, or myself with any questions. And once again, thank you for your time, guys.